My dear friends, I am sharing my thoughts on the present trends that are taking place in higher judiciary. Judicial independence at the crossroads, collegium opacity, post-retirement rewards, and eroding public trust. The higher judiciary of India occupies a unique place in the democratic framework. Unlike the legislature, executive, the judiciary has neither the purse nor the sword. Its authority derives entirely from the public trust in its impartiality and the Constitution of India and its independence. Over 7 decades, the Supreme Court has established itself as a final arbiter of constitutional disputes, a protector of fundamental rights, and a guardian of federal balance. Yet in the last decade, growing unease surrounds the credibility of the judiciary. Concerns have crystallized around 3 interlinked areas. Number 1, opaque collegium functioning in the appointment and transfer of judges. Number 2, post-retirement rewards in the form of political, gubernatorial, or statutory posts. Number 3, judicial evasion and delay in deciding cases of national importance. Together, these issues risk the eroding the very legitimacy of the judiciary as an independent pillar of democracy. The collegium system and the crisis of transparency. The collegium system was judicially created through the judges case SP Gupta versus Union of India 1981, Supreme Court's Advocates on Record Association versus Union of India 1993, and in pre-presidential reference 1998. The idea was to insulate appointments from the executive interference. However, the system has attracted the criticism from within and outside the judiciary. Lack of diversity. Studies have shown that the upper caste men dominate higher judiciary, with women, Dalits, Adivasis, and minorities grossly underrepresented. Certain states like Gujarat have been overrepresented in recent years, raising suspicions of political influence. The Supreme Court Bar Association has expressed grave concern recently over the disproportionately low representation of women in the higher judiciary. 3 women judges who were potentially in line for elevation, namely Justice Sunita Agarwal, Chief Justice of Gujarat High Court, Justice Revati Mohita Dera, Bombay High Court, and Justice Lisa Gill, Punjab and Haryana High Court, were superseded by Justice Pancholi despite Honorable Justice Nagaratna's dissent, a collegium member. Opaque decision making. The Supreme Court itself admitted in the NJAC judgment in 2015 that the collegium suffers from opacity and lack of accountability. Even after promising greater transparency, most of the collegium resolutions and decisions remain perfunctory. The lack of complete accountability and transparency is particularly egregious when dissent is a pillar of healthy democracy. As the Supreme Court has often affirmed that the right to dissent is a hallmark of democracy. This principle was powerfully articulated in Romila Thapar versus Union of India 2018 SCC volume number 10 753, which stated that dissent is a symbol of vibrant democracy. Voices in opposition cannot be muzzled by persecuting those take up unpopular causes. Suppression of dissent. Honorable Justice B.V. Ratna's reported dissent on collegium decision to elevate Justice Pancholi by questioning why Justice Pancholi, who was at rank number 57 in All India seniority, was preferred over the meritorious judges and women judges who are seniors, especially when the Gujarat High Court already has a representation of 2 judges in the Supreme Court, but it was not made public. The dissent notice of Justice Nagaratna was not made public. Reportedly, Honorable Justice Nagaratna's dissent also highlights that the Justice Pancholi was once transferred from Gujarat High Court to Patna High Court, which was apparently not a routine transfer. Justice Abhay Oka, Honorable former Supreme Court judge, also opined that the demand for public disclosure of Justice Nagaratna's dissent is justified, and selective speed and decisions keeping under the carpet. Some recommendations of the Honorable Supreme Court were cleared swiftly and appointments are processed with extraordinary haste by government, while selectively keeping several other recommendations of the Honorable Supreme Court in cold storage for years together by the government. This creates a perception that the appointments are not purely merit-based and that the executive is dictating. Executive means the government, central government is dictating terms, and that the judiciary has failed to assert itself and its independence. Aligning with executive in crucial and constitutional cases. The recently senior Supreme Court advocate Kapil Sibalji stated that since 2014, successive Chief Justices of India have failed the Constitution by towing the line of the Modi government. His critique, harsh at its sounds, rings true in the light of the recent history. Number 1. Justice Ranjan Gogoi, who presided over some of the most politically sensitive cases, later accepted a Rajya Sabha nomination from the ruling party, eroding public confidence in the judicial independence. Justice Sharad Arvind Bobde shied away from hearing several critical constitutional cases, including those related to civil liberties and federalism, thereby avoiding uncomfortable scrutiny of the government. Number 3, Justice D.Y. Chandrachud, despite eloquent public pronouncement about constitutional values, is accused of aligning with the executive or the government in crucial matters, right from Shivasena split case to delays in hearing challenges on electoral bonds case and abrogation of Article 370 and so forth. And the present Chief Justice of India, Justice B.R. Gogoi, who publicly declared B.R. Ambedkar as his ideological icon and vowed to uphold the Constitution, has also invited controversy. Apart from ignoring the dissent of Justice B.V. Nagaratna in respect of elevation of Justice Pancholi, questions dissent of Justice Pancholi, questions the dissent of Justice Nagar, questions also arose after it has emerged that the collegium has recommended CJA B.R. Gogoi's nephew for elevation to the Bombay High Court last week. Coincidentally, the Bombay High Court Chief Justice who recommended the elevation was recommended for elevation to the Supreme Court. Number 2, the reward culture, post-retirement appointments and rewards. Although Article 124 Clause 7 of the Constitution bars sitting judges from holding other offices, no restriction exists post-retirement. Governments have historically used this loophole to extend favors to the judges. Former Union Minister and Senior Advocate Arun Jaitley once bluntly stated that the pre-retirement judgments are influenced by a desire for post-retirement job. And he suggested that there should be 2 years cooling period after retirement, and there should be a gap before the appointment, because otherwise the government can directly or indirectly influence the courts and dream to have an independent, impartial and fair judiciary in the country would never actualize. Jaitley said this. He is a BJP leader. Jaitley had said this in the capacity of leader of the opposition of Rajya Sabha in 2012. The past decade, however, has seen instances where appointments were followed by judgments favorable to the government. Number 1, Justice P. Sadasivan, appointed Governor of Kerala in 2014, months after presiding over a bench that quashed FIR against Amit Shah in Sohrabuddin encounter case. Justice Ranjan Gogoi, nominated to Rajya Sabha in March 2020, barely 4 months after retiring as CJI, and he has presided over the benches deciding Ayodhya dispute, Rafale review and CBI director's case in favor of the government. Number 3, Justice S. Abdul Nazir, appointed Governor of Andhra Pradesh in February 2023, weeks after upholding demonetization as a part of the Constitution bench, and Justice Arun Mishra, appointed as NHRC chairperson in 2021 after his retirement. While still he was a Supreme Court judge, he had controversially praised the Prime Minister in open court, and he was on the bench of which diluted the SC/ST Prevention of Atrocities Act in 2018. Then there are High Court judges. Justice Abhijit Gangopadhyaya resigned in March 2024 and joined BJP within days and Justice Rohit Arya joined BJP after retirement. These cases show a troubling pattern. Even if no explicit quid pro quo is provable, the perception of impropriety is sufficient to corrode public confidence. Then judicial evasion, sleeping over cases of national importance. Equally corrosive as post-retirement rewards is the judiciary's reluctance to decide critical cases. Delay functions as a silent endorsement of the government's action. Article 370 and 2019 petitions were filed immediately after abrogation. The court deferred hearings until 2023, by which time the union government has entrenched its control in Jammu and Kashmir. In December 2023, the court upheld the abrogation, but the delay has already legitimized the government's action. Then Citizenship Amendment Act 2019, over 200 petitions were filed. 200 petitions were filed challenging CAA remain undecided more than 4 years later. The rules have now been notified, rendering challenges largely academic. Number 3, electoral bonds case 2017 to 2024. Despite multiple pleas for urgent hearing, the court delayed. Only in the March 2004 did it strike the scheme down as unconstitutional. After it had already influenced 2 general elections. Then Shiva Sena split case 2022. Delay in deciding the disqualification petitions enabled defectors to form government, and by the time the judgment came in 2023, the political outcome was irreversible. And 5 other cases, misuse of governor powers, prolonged pendency of disqualification under 10th schedule, and challenges to the formulas later repealed, also reflect judicial evasion. The selective urgency suggests that judiciary prioritizes cases in ways that avoid confrontation with the government. Then, unfortunately, the silence of the Bar Council of India and other state bar associations have largely remained silent. Instead of demanding accountability, they have often aligned with the government. Such silence is dangerous. Historically, the bar has been the first line of defense for judicial independence and constitutional morality, as seen during the emergency 1975-77. Its absence today deepens the crisis, and it is very regrettable. Then consequences for a democracy. So the cumulative effect of all these trends is alarming. Erosion of public faith, judicial independence appears to be compromised. Weakening federalism, central executive actions remain unchecked. Rise of majoritarian politics, courts' reluctance emboldens the authoritarian tendencies. Loss of moral authority. Once credibility is lost, judicial orders risk being ignored. The judiciary strength lies in public trust. Without it, it reduces to be a paper tiger. Then reform agenda. To restore faith in judicial independence, the reforms are urgent. That is, number 1, the cooling off period. Minimum 3 to 5 years before retired judges or resigned judges can accept gubernatorial, political or statutory posts. Then time-bound constitutional hearings. Set mandatory timelines for hearing and deciding the cases that affect fundamental rights and the democratic structures and constitutional importance. Then collegium transparency. Publish the detailed reasons for appointments, for recommendations, and disclose the dissent notes, and adopt diversity quotas. Diversity quotas giving representation to the socially marginalized sections, women and minorities. Then independent appointments to the commissions and tribunals. Selection through the neutral or parliamentary bodies and not the executive. Binding judicial code of conduct. Prevent acceptance of post or behavior that creates perception of bias, and revival of bar activism. Legal fraternity must speak up against the executive interference and political compromise. So the conclusion, India's higher judiciary is at a crucial stage and at crossroads, a decisive juncture. Collegium opacity, post-retirement rewards, and judicial evasion are not an isolated issues. They form a pattern of systematic compromise that threatens constitutional democracy. If judges continue down this path, the Honorable Court, Apex Court and Higher Judiciary continues this path, and the Supreme Court risks losing the credibility it painstakingly built since independence. To restore faith, transparency, accountability, independence, and a renewed commitment to the fearless adjudication and also commitment to the Constitution and democracy are essential. As father of Indian Constitution, Dr. B.R. Ambedkar warned, even a good constitution can fail if those entrusted with power lack integrity. The choice before the judiciary is now stark: to be remembered as the guardian of the Constitution or as its silent grave digger. Jai Bhim, Jai Bharat, Jai Constitution.